In other words, when a t-shirt says, "Let us turn up the beat," is that a company selling the t-shirt, or is that a statement printed on a t-shirt? That's not really clear, so that's not really how t-shirts are trademarked.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
In the United States District Court for the Northern District of California, this is a court order denying plaintiff's motion for summary judgment, but granting defendant's motion for summary judgment. No one suggests puns are copyrightable or patentable. This case presents a question of whether a pun may be protected under trademark principles. The answer is clear. While a source-identifying trademark may embody a pun, no one can claim exclusive rights to use the pun merely by printing it on t-shirts, other wearable garments and clothing, paper for wrapping packaging or tote bags, or similar products, and then calling it a trademark. Even if a trademark embodying a pun is otherwise enforceable where there is a likelihood of source confusion, the trademark holder cannot prevent others from using the pun in contexts that do not imply source. Plaintiff, in this action, has the registered trademark for the pun, "Lettuce, turnip, the beet," spelled using the vegetable names, lettuce, turnip, and beet. The Patent and Trademark Office allowed the registrations, but only after plaintiff proposed including the phrase on product labels and hang tabs. The application was rejected when plaintiff first suggested the phrase merely would be emblazoned across these products. While plaintiff may be entitled to continue to enforce those marks when used as source-identifying marks, or used in a source-identifying manner, it is not entitled to preclude others from using the joke on t-shirts or elsewhere. So, real quick, just to back that up, what does that mean? If you are emblazing a t-shirt or wrapping paper with the phrase, that's a little bit different than if you are using it as a branding function. In other words, when a t-shirt says, "Let us turn up the beat," is that a company selling the t-shirt, or is that a statement printed on a t-shirt? That's not really clear, so that's not really how t-shirts are trademarked. Rather, it's the brand. Fruit of the Loom appears on the tag. Fruit of the Loom is the brand. So they can use "Let us turn up the beat" on the tag as the brand, but they can't own the pun on the face of the t-shirt. So even if the name of their company is "Let us turn up the beat," and they write that on the front of their t-shirt, "Let us turn up the beat," that's not the same as if they were using it as the source branding function of a trademark. So they can use "Let us turn up the beat" as a trademark, but not as the text on the... Actually, I'll rephrase that. They can use it as a trademark and gain protection on the tag. But if they try to use it on the t-shirt, they can use it on the t-shirt, but they won't have trademark protection because just because it's on the t-shirt or on the wrapping paper or on the box or something like that. It has to be their brand. Plaintiff is LTTB, Let Us Turn Up the Beat, which describes itself as a small business that has grown from a street vendor to an online storefront with 10,000 followers and sales of $1 million. There is no dispute that LTTB owns 4 U.S. trademarks, 2 of which have allegedly become incontestable due to continued use after the required statutory period. Defendant Redbubble, a company based in Australia, operates what it characterizes as a global online marketplace on the internet where independent artists can upload and sell creative designs on everyday products such as apparel, phone cases, stickers, bags, wall art, and so on. This action arises from the fact that products featuring the phrase "Let us turn up the beat" or similar phrases allegedly have been offered for sale on defendant's site. Redbubble seeks summary judgment on grounds that it cannot be held liable for any trademark infringement by third parties, given efforts it insists it has made to respond to any complaints made by LTTB and to remove any allegedly infringing products. Redbubble also argues that apart from whether or not allegedly infringing products have been offered for sale on its site, LTTB is not entitled to preclude others from using the "Let us turn up the beat" pun absent evidence of source confusion. Although there might otherwise be triable issues of fact as to whether Redbubble could be liable for the marketing of allegedly infringing products on its site, it is entitled to summary judgment because LTTB is not entitled to preempt the use of the pun under the guise of trademark law. Further factual background is set out in the discussion below, where material. Summary judgment is proper if the pleadings and admissions on file together with the affidavits show there is no genuine issue as to any material fact, and that the moving party requesting summary judgment is entitled to judgment as a matter of law. The purpose of summary judgment is to isolate and dispose of factually unsupported claims or defenses. The moving party always bears the initial responsibility of informing the district court of the basis for its motion, identifying the portions and pleadings, admissions, together with affidavits that they believe demonstrate the absence of genuine issues. If it meets the burden, the moving party is entitled to judgment as a matter of law when the non-moving party fails a sufficient showing on essential elements of the case with respect to which he has a burden of proof at trial. The non-moving party must set forth specific facts showing there is a genuine issue for trial. The non-moving party cannot defeat the moving party's properly supported motion for summary judgment simply by alleging some factual dispute between the parties. To preclude the entry of summary judgment, the non-moving party must bring forth material facts that might affect the outcome of the suit under the governing law. Factual disputes that are irrelevant or unnecessary do not count. A trademark is defined in 15 U.S.C. 1127 as any word, name, symbol, or device or combination thereof used by any person to identify and distinguish his or her goods, including a unique product, from those manufactured or sold by others, and to indicate the source of the goods even if that source is unknown. To be registered, a mark must be capable of distinguishing the applicant's goods from those of others. In this action, plaintiff LTTB's founder, owner, and predecessor, Elektra Prince Gorsky, who graduated from the Fashion Institute of Technology in New York in 2007, winning the famed Critics Award as one of the most promising designers in her class. Gorsky has advanced silkscreen classes at FIT and the School of Visual Arts and is alleged to be a designer and artist widely considered as a master printer among her industry peers. In 2011, Gorsky allegedly created the Let Us Turn Up the Beat trademark and her first apparel and product designs using the mark as both a source identifier and as a graphic design element. Plaintiff's initial attempt to register the trademark, however, resulted in the following response from the trademark office. Registration is refused because the applied for mark, as used on the specimen of record, is merely a decorative or ornamental feature of the goods, does not function as a trademark to identify and distinguish applicants' goods from those of others, and to indicate the source of applicants' goods. Here, the applied for mark, Let Us Turn Up the Beat, as shown on the specimen, is merely ornamental because the mark appears in a large font across the center of the packing box, tote bag, and shirts, where ornamental elements may appear on such goods. The consumer is likely to assume from this type of usage that the mark is merely a decorative feature of the items and does not indicate the source of each item from those of others. LTTB obtained registration of the various forms of Let Us Turn Up the Beat marks only after submitting specimens on which the phrase appeared on product labels or hang tags, as opposed to being displayed boldly across the face of the products. The issue, among others, presented in these motions is whether LTTB has a viable infringement claim where the accused merely displays the pun and does not otherwise include any indication that they are produced or licensed by LTTB. Redbubble's defense on this point may be characterized as either implicating the rule that decorative or ornamental features are not subject to trademark protection or the exclusion for aesthetic functionality. Case law has not always clearly distinguished between the two concepts, which undoubtedly are related and overlap. For purposes of this motion, however, the precise nomenclature is not critical. The issue is, as noted above, whether LTTB may rely on trademark law to obtain an exclusive right to sell products such as apparel, phone cases, stickers, bags, and wall art displaying the pun. The answer is no. The doctrine of aesthetic functionality has a somewhat checkered history. The automotive court explained, the doctrine of aesthetic functionality is often traced to a comment in the 1938 restatement of torts. When goods are bought largely based on their aesthetic value, their features may be functional because they definitely contribute to that value and thus aid the performance of an object for which the goods are intended. The automotive court observed, however, that the Vuitton et Fils SA versus J. Young Young Enterprises, Inc. case of 1981, that the Ninth Circuit emphatically rejected the notion that any feature of a product which contributes to the consumer appeal and saleability of the product is, as a matter of law, a functional element of the product. Indeed, a trademark which identifies the source of goods and incidentally services another function may be entitled to protection. Thus, under Vuitton, the mere fact that the mark is the benefit that the consumer wishes to purchase, such as I'm assuming like the Supreme trademark, will not override trademark protection if the mark is source identifying. That said, however, the automotive court made clear that in Vuitton, aesthetic functionality was dealt a limiting but not fatal blow. The present case presents circumstances undeniably calling for application of the aesthetic functionality doctrine. There is no evidence in the record from which a reasonable trier of fact could conclude that consumers seek to purchase products based on LTTB's reputation, whether genuine LTTB products or those produced by any other competitors. Rather, as LTTB's evidence and arguments make clear, consumers are interested in purchasing products that display the pun. LTTB argues Redbubble cannot contend aesthetic functionality would permit a t-shirt bearing a copy or near copy of the Nike swoosh logo or some other registered design mark, and therefore it should not be heard now to argue that copying these designs is permissible as ornamentation. At first blush, that argument appears consistent with the holding in Automotive, which rejected a claim that the defendants necessarily had a right to use Volkswagen and Audi logos on the products they were selling. The distinction, however, is manifest. Nike, Volkswagen, and Audi all developed their trademark rights by selling goods under those brand names and have at least arguably gained brand loyalty for those products as opposed to mere consumer interest in their specific names, independent of the reputation the companies developed when selling the products. Redbubble properly invokes International Order of Job Daughters versus Lindenberg and Company, to support its argument that LTTB's registration of the marks does not preclude it from marketing products displaying the pun. In Jobs Daughters, the case, the defendant marketed jewelry that had the Jobs Daughters trademark, which belonged to a young woman's fraternal organization. The court observed it is not uncommon for a name or emblem that serves in one context as a collective mark or trademark also to be merchandised for its own intrinsic utility to customers. We commonly identify ourselves by displaying emblems expressing allegiances. Our jewelry, clothing, and cars are emblazoned with inscriptions showing the organizations we belong to, the schools we attend, the landmarks we visited, the sport teams we support, the beverages we imbibe. Although these inscriptions frequently include names and emblems that are also used as collective marks or trademarks, it would be naive to conclude that the name or emblem is desired because consumers believe the product somehow originated with or was sponsored by the organization the name or emblem signifies. The court held the plaintiff had failed to show a typical buyer of the defendant's merchandise would think that the jewelry was produced, sponsored, or endorsed by plaintiff's organization. Although Jobs Daughters was decided after trial, it is highly instructive here. If anything, the primary distinction between Jobs Daughters and the circumstances here cuts against LTTB because it cannot plausibly allege that there is any organization to which consumers might wish to express allegiance by purchasing products displaying the pun. LTTB is attempting to sell the pun it claims as a trademark. The products are simply the vehicle for distributing the claimed trademark rather than the other way around, where a trademark is used to identify the source of goods. While companies that have already established a famous mark for selling a product, for instance, Coca-Cola, Volkswagen, Audi, or Nike, may therefore also be able to exploit consumer interest in the mark by selling t-shirts or other products emblazoned with such marks, that simply does not present an equivalent issue here. Redbubble does not suggest that LTTB's registered trademarks are per se or automatically invalid, and nothing in this order should be construed as so holding. Redbubble instead appropriately frames the argument as precluding LTTB from showing a likelihood of confusion as to source, where the mere use of the pun on the face of the various products cannot be source identifying. LTTB obtained its registration by submitting samples showing the claimed brand being used on labels and hang tags. Were some competitor to use a brand name in a similar fashion that created a likelihood of confusion, liability might follow. LTTB may not, however, recover for alleged trademark infringement based on any competitor's use of the very kind of designs that the PTO found not to be eligible for trademark protection, as explained in Jobs Daughters. Quote, "Our holding does not mean that a name or emblem could not serve simultaneously as a functional component of a product and a trademark. That is, even if the Job's daughter's name and emblem, when inscribed on Lindeberg's jewelry, served primarily a functional purpose, it is possible that they could serve secondarily as trademarks if the typical consumer not only purchased the jewelry for its extrinsic functional use and aesthetic appeal, but also inferred from the insignia that the jewelry was produced, sponsored, or endorsed by Job's daughters. In this case, however, LTTB has presented no evidence sufficient to create a triable issue of fact that any purchaser of alleged infringing items inferred from use of the pun that the product was produced, sponsored, or endorsed by any particular person or entity, such as LTTB. Still, nothing in this ruling precludes LTTB from enforcing its rights against a defendant who markets products, misleadingly suggesting LTTB is the source. Finally, the fact that 2 of LTTB's marks are now incontestable under a statutory scheme does not call for a different result. First, as noted above, nothing in this order concludes LTTB has no viable trademark. Rather, LTTB merely cannot preclude others from displaying the pun on products, as long as there's not a showing of source confusion. Second, even if the validity of the marks were at issue, statutory incontestability does not preclude challenges based on arguments that marks are functional, and there has been no argument or showing that the statutory exception does not apply where the contention is the claimed mark is aesthetically functional. In light of the conclusions of this order, the parties' disputes as to whether Redbubble could be held liable for sales through its site of allegedly infringing products need not be reached. Redbubble's motion for summary judgment will be granted. Plaintiff's motion is denied. A separate judgment will issue. It is so ordered July 12th, and you can't see it here, but it's Richard Seaborg, United States District Judge. So that's interesting. I hope that maybe clarifies some of the distinctions or differences between what trademark protects and what it doesn't. So what they're talking about, just for reference here, we'll use my shirt. We'll use my shirt here. This is a shirt made by Kuhl, Kuhl. And here is something that's trademarked. This is their trademark logo. If you look at the tag on the back, which I can't show you, that would have their trademark logo. But if it just said Kuhl, Kuhl, across the front here, how would you know that that wasn't just a fun misspelling of the word cool, Cool? How would you know it was a brand and that you weren't allowed to sell clothing under that name? You probably wouldn't. Kuhl, the brand, the company and the brand, would need to establish itself in the marketplace akin to Coca-Cola and Nike and Audi, etc. Then they can say that people recognize their trademark and they have a famous mark and all that. This Let Us Turn Up the Beat mark was not famous and was not on the tags that Redbubble, the defendant, was selling. It was emblazoned across the front. So Redbubble can sell all the t-shirts it wants with Let Us Turn Up the Beat, the pun, on the front. What they can't do is put LTTB or Let Us Turn Up the Beat on the tag or make a little design like this that's Let Us Turn Up the Beat as like a little logo. If it's clear that it's a logo and source identifier, then it can be a trademark. So LTTB has the trademark so long as they only use it in that source identifying way. So let us know what you think about that in the comments below.
So they can trademark the pun, but they can't stop other people from using the pun for comedic effect, not as a source identifying effect.
Right. And even then, like, let's take us one step further. Let's say that Let Us Turn Up the Beat becomes the most famous clothing brand ever. It's still a pun, and there's going to be a fight over whether you can actually stop people from using the pun on their own things. Again, Nike isn't an English word for shoe or something like that, or isn't a pun, et cetera, et cetera, et cetera. So if you put Nike or you put the Nike swoosh on there, that's not the same thing as writing out the quick brown fox jumped over the lazy dogs. Could you really make a clothing company called the quick brown fox jumped over the lazy dogs? Yes. Could you put that as the tag? Yes. Can you put that on the front of the shirt after your clothing company has become insanely famous and nobody can ever use the quick brown fox? I don't think so. I don't think it goes that far. So I'm gonna say that the pun still remains not trademark protected when used as the text of the thing on the face of a box or wrapping paper or t-shirt or something. But reasonable people could disagree. Tell me what you think in the comments below. So that's our show for today. We are going to hold a Wednesday evening stream, probably like a 7 p.m. Eastern time or 6 p.m. Eastern time kind of thing. Let us know what you think of our stories and things in the chat. and in the comments below. Thank you for joining me today, everyone. I am Leonard French, your favorite copyright attorney. Thank you to our patreon.com/ljfrench and sponsors.org/law supporters who support us financially and make these stories possible. Thank you to Joshua Davis, who is supporting us in July at the $500 level. We're going to make a video for Joshua about the TandaPay service that he has developed. It is a social insurance program that is based on the blockchain, and we're going to see what's super interesting about this. Thank you very much to our $50 plus supporters, Jonathan Steele, Gavin Barnard, Kyle Mudrak, Eevi, I almost said Andy, yeah. Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky. Thank you very much for your support at the $50 level, and thank you to the $5 plus supporters, including Joe Tyson, who I forgot about, so I'm making it up to him, who are scrolling on the LED panel behind me and will be in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. This has been Kaylee with us here in the studio. Brandon and Tactical and Kurt Mueller have been in the virtual studio. Thank you very much for joining us there. I'll leave some room here for the editor to put some dog video, but here is also a dog for you. Hup. Good boy, that's my dog. This is Nico. Nico has also been in the studio today. Up, and I hear an Ilsa. Ilsa. Do we have an Ilsa coming over? She's gonna give Kaylee her butt because Ilsa likes her butt rubbed. Of course, which dog doesn't like her? And she's a black dog. She's a dark dog, so you can't see her on the camera. That's great. You are the nicest dog. You are the nicest golden retriever anybody's ever known.
Ilsa. I'd rather have your face than rubbing your butt.
Love you all. Bye.